State versus VanMeter.
Good morning.
Good morning. Both sides will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes, and we're ready to proceed when you are.
Thank you. May it please the court. Mr. Prosecutor, I'm Chris Ockerly. I represent the appellant in this matter, Mr. Christian VanMeter. Your Honors, if you would, I would like to reserve just 3 minutes for rebuttal.
Thank you.
Your Honors, there are 4 issues in this case based on 2 assignments of error. The issues number 1 and number 2 are similarly aligned. That is whether the evidence presented at trial was legally sufficient to support a conviction of all the elements of felonious assault. Specifically, that the appellant, the defendant in this matter, caused harm and knowingly did so. The second issue is to the endangered children charge, and whether the defendant appellant violated a duty of care and did so recklessly. Those are the first 2 issues. The third and fourth issues are also similarly aligned. Issue number 3 is after the presentment of all the evidence at the trial in this case, whether the jury had lost its way, creating a manifest miscarriage of injustice by convicting the appellant of felonious assault. Issue number 4 is the same, whether a manifest miscarriage of injustice occurred by convicting the appellant defendant of endangering children. Your Honors, the defendant there was an incident that took place on June 28th of 2013 in which my client was indicted on 2 counts, a felonious assault count and endangering children count, on August 28th of 2013. That case proceeded to trial on June 12th of 2014. He was subsequently convicted after trial by the jury, by a jury. And of course, we are appealing that decision by the jury. Your Honor, as you probably have seen, the testimony is deep. There are lots of facts to these cases, to this case. Over 600 pages of transcript, and there's just a lot of facts that you will find in there. The biggest facts that you're not going to find, though, is anything that indicates that Mr. VanMeter actually harmed the child, knowingly harmed the child. That it was, number 1, the defendant, and if it's determined it's the defendant, that he knowingly hurt this child.
You're speaking
under the felonious assault.
You're speaking of direct evidence.
Direct evidence, yes, it's direct evidence. But even the circumstantial evidence, there is limited information in regards to what the circumstantial evidence is, Your Honor. What the evidence that they presented, really in this particular case, was on the morning of June 28th. My client had the child upstairs, not in view of anyone, began crying. The sister of the mother of the child went upstairs to check on him and came down and said, "Hey, my client's a little irritated. Mom, you should go check on the child."
Was he holding the child? Was the child in the seat? These facts, it's so intensive, it's hard to understand this simple condition when the injury is alleged to have taken place.
Yes, Your Honor. I believe the testimony presents itself that the sister went upstairs and the baby was in his arms. Mother goes up and the baby's in my client's arms as well. And she takes the baby because the baby's crying.
Well, she also takes the baby, based on her testimony, because Dad seems very angry and makes some statements that were troubling regarding his anger and his frustration directed at the child.
Yes, and that's correct, that she does do that at that time. But if you look at the transgression of the day, because they have testimony from the mother of the child, the sister of the mother, and the grandmother, they all testify. They don't see any type of injury of the child, no swelling of the leg that day. That father, my client, the appellant, was a good father, that they hadn't really seen him act this in an irritated manner in any type in the past. In fact, I can't remember which witness it was. I think it was the sister that said I believe it was the mother, the grandmother that had said this is not something she would expect out of the father for something like this to occur. After they, in terms of determining he's irritated, they take the child to a chiropractor the next day, who he testifies doesn't remember doing any type of manipulation of the child.
But they take the child to the chiropractor, as I understand it, because the child was so fussy and could not be consoled, and they had to, the way I understood the testimony, they had to basically cradle his legs.
And I believe that was the testimony of the mother of the time, that yes, they had to cradle the legs. But I think also the testimony of the sister who indicated that she was a STNA, state tested nursing assistant, that there was no, that she did not believe that the leg was broken based on what she observed. And it was her thought that it might be a pinched nerve at that time.
Well, but the whole point is there was something that was causing the child discomfort.
Yes, and there was something that was causing the child discomfort. And again, that goes back to what the state had determined. The whole point of the state was the last person that held the child must have caused this injury. And that's really the basis of the child. We don't know when exactly this child was injured and how bad, because the child's leg really didn't start to swell until after the child got home from the chiropractor the next day. And there's no determination. In fact, I believe Dr. Steiner, who's the state's expert witness in this case, was not able to determine when exactly that the child had hurt its leg. And if you take a look at the evidence that was presented and what the detective knew at the time, he had testified, he had heard from Dr. Steiner that not only was there a problem with a broken leg, but there were two bilateral subdural hematomas, which is bleeding on the brain, and there were two injuries at that point, and had indicated that to the detective that one of them occurred back in April of 2013 when the defendant had taken the child to Akron Children's. The detective really focused if you read the testimony, he focused his determination at that point on the defendant. It comes out of trial, though, that from the Dr. Steiner that he had not reviewed a CT scan from April of 2013 that actually indicated there was no brain trauma when the defendant appellant took the child to Akron Children's. And he then determined that that first brain injury could not have occurred, and that was at the trial. So he changed kind of his expert opinion after reviewing all the information that should have been available to him prior.
I'm not sure I understand that. So his initial opinion was there was two hematomas.
Correct.
And one was old and had healed, and
Correct.
one was fresh.
And that's correct.
And he attributed it initially to the time that the child was admitted to the hospital earlier in 2013.
In April 2013,
In April
yes.
2013. And then upon being shown a CT scan, he changed his testimony to say that he was mistaken and there wasn't a second hematoma?
He determined that the second hematoma, or the initial one, the older hematoma, was not, it did not occur at the time of the April 2013 visit to the doctor when my client
When the
took-
original CT was done?
Correct. And then he testified that later on that the hematoma would have occurred about the same time that the mother of the child had dropped a frying pan on the child. And she testifies to that in the trial, that she had dropped a frying pan on the child's head, that she had fell down the stairs with the child in a car seat as well during that time frame. And also, to a much lesser extent, at the same time, Dr. Hamilton was doing some sort of manipulation on the brain, and based on reading the testimony, it sounded like that. I mean, he kind of just takes the baby's brain and kind of and tries to gently pull the plates apart a little bit. But he was doing that all at the same time when the two other incidences from the mother of the child took place. And there's no other explanation, rational explanation, that was ever given from, excuse me, any evidence to show that first hematoma had taken place because of the defendant, my client. In addition, there's no evidence at all in regards to my client causing any harm for the second hematoma. There's no evidence in there, other than when they took the child in to check his leg, they also found a current brain bleed at the same time.
Dr. Steiner questioned in regard to when the first hematoma, any hematoma as far as that goes, if they could show up, that if you get treatment or you do a CT scan too early, they may not appear, or may not be able to be demonstrated on a CT scan too quickly.
There was from my recollection of reading the transcript, I don't believe there was any questions followed up either by the state or the defendant's counsel that indicated whether it would show up at a later time.
Okay, thank you.
Yes. Questions? Make sure.
No, but you're almost into your rebuttal.
Okay. Well, then what I would just say, again, it's fact intensive. I put a lot of information into my brief. All I would ask is that you take a real close reading of the way I laid it out, the knowingly factor, the fact that whether it was him that did it and whether he acted recklessly in both the two assignments of error, whether there is a sufficiency argument at the end of the trial, as well as a manifest miscarriage of injustice, causing there a need for a new trial. Thank you.
Thank you.
How much time did I reserve?
You have 2.5 minutes.
2.5 minutes. Thank you.
You may proceed.
Thank you, Your Honor. May it please the court, I'm Matthew Kern on behalf of Dean Holman, Medina County Prosecuting Attorney, and I represent the state in this matter. I guess I will consolidate the two assignments of error for today's discussion purposes, since they both rely on facts adduced at trial. And in that sense, I understand there are really kind of four main contentions that the defendant advances. The first is identity. The second is whether he committed the felonious assault knowingly. The third is the violation of the duty of care. And the fourth is the recklessness issue. And I know that they were split between sufficiency and manifest weight, but for today's discussion purposes, I'm going to kind of consolidate those. The facts of this case show that on the morning of June 28, 2013, the defendant, Christian VanMeter, was alone with his son playing upstairs in a bedroom. Before that time, Mr. VanMeter's wife testified that the child was fine, was smiling, was acting happy, did not appear to be any kind of physical discomfort, was fine. 15 minutes later, she testifies, the child, who I've called Junior in the brief to protect the name as much as possible, Junior is, for lack of a better phrase, screaming bloody murder. That is crying, is unconsolable, and the only way the family testifies that they can make the child temporarily stop fussing, crying, screaming is by essentially holding the child's legs in such a way that it essentially immobilizes the leg and stops it from moving temporarily. When the family goes to the room to find what's going on, when they hear these screams of pain, the defendant says to them, "You need to take this effing kid. I can't effing deal with him." And that's transcript page 240. The wife, Rebecca, wanted to take Junior to a chiropractor at her parents' suggestion because that's the way the family generally responds to issues involving what appears to be physical discomfort. They use the services of chiropractors. In the brief, in the defendant's, the appellant's brief in this case, there appears to be some suggestion, I think around page 10 of the appellant's brief, that Dr. Lash, the chiropractor they first saw, is the one who somehow caused these injuries. The testimony at trial specifically refutes this claim. He testifies that, well, actually Rebecca testifies, and I think Dr. Lash also says that he never even got the child out of the car seat, that he used what's called Logan Basic, which is essentially just light touching that wouldn't even bruise the skin of a tomato. So the suggestion that somehow Dr. Lash is the one who twisted around the long axis of a bone and caused a spiral fracture to Junior's right femur does not appear to be supported at all by the record.
Where does the light touching on his first visit take place? What part of the body was the chiropractor examining? Both the head and the leg and the hips?
I believe
Because they didn't take it out of the seat.
Sure. I think he's discussing, and if I can refer briefly, he, I believe, describes that he was using Logan Basic. Junior was crying and upset. We brought him into the office. He touched the leg a little bit, but did not take him out of the car seat and seemed pretty much unsure what to do because he did not normally adjust infants. So he touches the leg very lightly, maybe some on the sides, but no, does not. And Rebecca is in the room the entire time. She does not see him with a violent twisting in motion, nothing of that sort.
Was appellant there at the time? Also in the room?
No, I don't believe he was at that particular appointment. I might be wrong on that.
Now, I had a little bit of confusion with what was in the briefs as well. I don't remember if it was Dr. Steiner or Dr. Lash testified that, or I thought that's what I read, but somebody testified that Dr. Lash actually moved the leg, and it did move at that point in time. The broken leg.
So I think my understanding from Dr. Lash's testimony is that while he touched the leg and it caused the leg to move, and Junior therefore experienced obvious discomfort from the leg moving.
Did he immediately cry?
That's my understanding from the record.
Okay.
Basically, any attempt to move the leg or that allowed the leg to swing freely resulted in obvious discomfort to the child.
And Dr. Lash didn't realize it was broken at that time? Or he didn't, if it was broken or whatever?
He testified that he does not normally adjust infants. This appointment happened on a Saturday morning when Dr. Hamilton, who is their normal chiropractor, who had previously adjusted Junior, Dr. Lash was not really, it doesn't seem from the record that he was that comfortable doing anything beyond just kind of basic observation and just kind of very light, more or less probing in my way of describing it. I'm sure there's another medically appropriate way to describe it, but that's what it seems to appear to me from the record. So his obvious, I wouldn't say discomfort, but he doesn't adjust infants normally, so he's kind of outside of his comfort zone. He's not looking to go beyond.
So the state's theory was the leg was broken at that point, and
Yes.
Dr. Lash just basically missed it.
More or less. And the reason why I think it's actually very plausible that he would have missed it is this is not a compound fracture. This is not one where there is a bone protruding through the skin or anything like that. This is a spiral fracture, which would not, aside from the obvious discomfort at any movement of the leg and the obvious nerve ramifications associated with that, a chiropractor would potentially miss that as long as he was looking for a pinched nerve or some other chiropractic explanation as opposed to a broken bone. And that kind of plays into the state's theory as for the child endangering here, is that the person who knew what had happened is the person who broke the child's leg. Dr. Steiner testifies that this type of injury, for as young as Junior was at the time, that Junior was not mobile. Junior couldn't engage in action to break his own leg. He couldn't really move about in a way that would cause these injuries. And so, to Dr. Steiner, the expert who testified in this case, that means that somebody had to do this act to him. And the timing of the testimony, Junior was fine beforehand, and then while he's alone with the defendant, who is visibly upset and is using obscenity when describing how angry he is with Junior, when parents and family show up to investigate the loud, visceral cries of the child, he's alone with the child, visibly angry.
How does it work, though, in regard to child endangering, if I understand the mother made the arrangements, but I don't think anybody's refuting that she was the one that usually took the child to the doctor?
Correct.
He did. I don't know if he was in the room with her, but my understanding is that he attended with her.
My understanding is he went, I think, on the second
But not that person.
trip. Might be, is my understanding, although I could be mistaken on that.
Okay, I guess my question is to the state, in regard to the child endangering, the child was taken for medical attention, and according to the state's theory is the doctor missed what was wrong with him. So how is that the responsibility of the defendant?
Well, I would say this, is that the doctor is relying because Junior is of an age where he's not communicating himself, right? So Junior can't say, the defendant really messed with my leg and it really hurts. He's not able to say that. The person who can speak for Junior in this instance to provide medical attention in a timely manner is the person who knows what happened, right? The person who knows what happened is the defendant who engaged in the twisting action to cause the spiral fracture.
So it's not I'm sorry for interrupting, but I just want to make sure. So it's not necessarily not taking him for medical attention, but not giving the proper information to the doctor to be able to treat him.
He is in fact withholding vital information that he knows is uniquely relevant to the medical treatment of the child. He is refusing to provide that information, either to doctors, either Dr. Lash, Dr. Hamilton, or Dr. Steiner when they take the child to Akron Children's. And he's refusing to provide that information to the person that, on brief, he says is the child's primary medical provider, his wife, Rebecca. He is withholding that information. He is affirmatively saying, I don't know what happened. He is the one person who, in fact, does, directly.
But again, to my earlier question, in order to arrive at that conclusion, we have to rely on circumstantial evidence because there's not any
No.
direct evidence.
In direct evidence, no. No one sees him breaking the child's leg. No one sees him either throwing the child in the air or anything like that. No one testifies that they saw that. But there's only a 15-minute window here. The child was fine. The child was smiling. The child was happy. Did not appear to be any signs of discomfort. And then 15 minutes later, the child is screaming in agony. And the rest of the evidence in terms of, basically having to immobilize the child's leg for the child to temporarily stop crying in pain. Taking the child to Dr. Lash, who he testifies the child was already in discomfort. Rebecca, her main complaint after they saw Dr. Lash that morning is that he didn't do enough. Not that he was so harsh to the child that he's the one who potentially broke the child's leg. All of that evidence is consistent with the child's leg already having been broken.
What do we do with the fact that the state's expert, initially opined that the subdural hematoma happened at a time that was consistent with the child being with the father, and then later had to go back after picking up that CT scan, says, well, no, it didn't really happen then. How do we review that?
Well, I think Dr. Steiner's testimony is informative in a couple of ways. One is he testifies that the injuries, and subdural hematoma, I don't pretend to be a medical doctor. Obviously, the Juris Doctorate is a separate issue. But I don't pretend to be a medical doctor, but subdural hematoma seems like the wrong phrase to describe what Dr. Steiner said the CT scans from April had shown. It wasn't necessarily that there was a bruise, which is my understanding what a hematoma is. He said that there were brain bleeds shown in the CT scans, which...
The bruise sounds like it would be a bruise on the surface of the skin, whereas a brain bleed is an internal...
more serious injury.
Right.
And my understanding from the record is that Dr. Steiner says that there were active brain bleeds shown in the CT scan. So that bears mentioning. And he testifies that those injuries are inconsistent with the purported ways that Rebecca and the defendant in his statements to police said that the child may have been otherwise injured, the fall down the stairs or the frying pan incident. He testified were impossible to cause these particular injuries. He said, in fact, that the more recent injury, the still active bleed at the time of the CT scan, was probably from a violent shaking episode, I believe his testimony was, which all plays into the background circumstances of this.
But in follow-up to Judge Moore's question, nonetheless, it seems as if he either didn't review all the medical records before he came to his medical conclusions, or he read, if he saw the scan, he read it incorrectly and did change his medical opinion during trial. Is that a fair assessment?
I don't recall him changing his testimony like from direct to cross back to redirect. I don't recall that happening. I think when he was reporting the incident at the time, he was under the impression, probably because medical doctors normally rely on information from charts and other information from doctors in the course of their treatment, that he was understanding the scan to have been done that day. And then once he reviewed the records and saw that the scan had actually been performed previously, he had corrected himself and with his understanding of the case by the time he came to testify. So at the time of his testimony, he was very clear and consistent with his understanding of the facts of this case and the treatment and all of the diagnoses. In fact, he goes consistently, transcript pages 260 and 272, that this is an injury that does not occur without a traumatic event occurring. That's with the benefit of the CT scan. He testifies that the child's injury is a spiral fracture to the right femur, which on transcript page 262, he says is a twisting around the long axis of the bone, something the child could not do themselves. And transcript page 268, again, this is all during his direct testimony. He says that the defendant's explanations to police and the wife's statements as to other things that may have happened to Junior, that those explanations were not medically possible in terms of causing the injury shown either on the CT scan or this spiral fracture of the child's right femur. So,
And you're out of time.
I appreciate that. And for all those reasons, I respectfully ask the court to affirm.
Thank you.
Thank you.
You may proceed.
Thank you, Your Honor. A couple of things just to clarify. In terms of my client having the child and screaming pain, the testimony from the mother of the child was that she admitted that she told the detective that the screaming was no different than the normal screamings from the child that she had had in other occurrences. So that's one particular piece. this child screaming, but it's no different than just normal occurrences.
So it's not a child crying because he's hungry, as opposed to a child in severe pain.
She testified that she could not tell that cry was any different, that she had told a detective that during the course of the investigation. Okay. As far as the Dr. Lash issues, okay, Rebecca testified, and if you look in the facts, I did cite the locations in my fact sections, but Rebecca testified that Dr. Lash took the child out of the seat, did do some manipulations with the leg, indicated that Dr. Lash's actions alarmed her at that visit. Dr. Lash had testified, I did not take out the seat. I did not touch the leg. Later, Dr. Steiner testified, Dr. Lash told him that he had put the child through a full range of motions. Dr. Steiner didn't say that he had taken him out of the seat, but I don't know how you put a child through a full range of motions without taking a child out of the seat. So I don't know that Dr. Lash's testimony can be really, you've got two different pieces of testimony, and one of them being Dr. Steiner. Finally, if you take a look over the 8 witnesses that's presented by the state, not one says this had to be him. They all give some information and then you kind of leave it to the jury, and I understand a lot of it's circumstantial, but not one person, not a detective, not a doctor, not 3 doctors, none of them, not the mother of the child, not the sister that testified, not the grandmother, not one of them said this was the person that did it. I have no doubt that this is what happened. No one said that. Not one person said
Well,
any of that.
that's not unusual in child endangering cases, right?
I'm sorry?
That's not unusual in cases of I mean, you just don't have someone who breaks a child's leg or does something like that in the company of other people, typically.
I understand that. There are other people home. I believe I'm probably out of time, so.
Allowing you to answer her question.
Thank you, Your Honor.
Thank you. Thank you. The court will take the matter under advisement, and a written opinion will be issued and sent to both parties, and you can also look on our website. Thank you.